So thank you all for joining us this afternoon. My name is Emily Kile. We do meetings by Zoom, FaceTime, phone, or come into the office. So we look forward to an opportunity to serve you as best we can. And you can reach out to my staff if you have any questions or decide to make an appointment or have some general questions about how guardianships or special needs trusts work. So thank you all so much for joining us today, and we'll go ahead and get started. So we're going to cover guardianships, what to expect. I have these backwards, I suppose, costs and when and why you might want to do them, and special needs trusts. And we're going to do special needs trusts first, and we're going to do guardianships second. So I know some of you might be more interested in one topic or the other, and sometimes people have questions about both because it's sort of maybe is something you want to think about as your kids turn 18. And so that's why we put the two programs together, or the two topics together. So the goal of a special needs trust is to be able to have funds available, but not have them counted against the individual, mostly for SSI and all-text purposes. The person's on Social Security disability benefits and they're on Medicare, then their assets don't make any difference, right? The richest person could get Social Security disability and be on Medicare, and it doesn't matter. But for the folks who are going to be on SSI and or all-text benefits, then they can't have more than $2,000. And so the goal of the trust is to make sure that we can have lots of money if it's available, or a little bit of extra money, whatever that might be, to benefit the beneficiary who's receiving those benefits, because we all know that those benefits really provide basic services. And so special needs trusts are there to do a whole bunch of other things: buy eyeglasses or dental care, have an extra caregiver, pay for clothing or cell phone bills, get a new computer for the beneficiary, or some kind of assistive device for communication, or a vehicle to make it easy for the person to get around. So the money in the trust can be used for lots of things. We're going to talk about two different kinds of special needs trusts. And for both of those, once there's any money titled to the trust, it's really important that you or your successor trustee understands that the trust and the assets have to be reported to the agencies that are providing services, which most likely are Social Security and Access or all-text. And so the trustee has to make the decisions about when to make distributions, what kind of distributions to make, so that they can do their best to not have the person lose the government assistance that they otherwise would be receiving. So the sort of what makes the special needs trust extra special, so to speak, is that the trustee is the one who has sole discretion with regard to distributions. So the beneficiary can request money, they can request that things be purchased for them, but all of the discretion is in the trustee. So the trustee can say yes, the trustee could say no, the trustee could say, you need a vehicle, but this is a more appropriate kind of a vehicle for you. Or you need clothing and this is a more appropriate budget for what that cost might be. Or maybe they're going to replace the phone, every 3 years or something like that. So everything's at the discretion of the trustee. I say that the beneficiary can't demand access, which what I mean is, again, they can yell and scream that they want the money, but they can't actually get access to the trust funds. Only the trustee has access to the funds. So obviously the beneficiary doesn't have any control over how those monies are used, how they're invested, how they're spent. That's all on the trustee. As I said, the government benefit programs are really only meant to provide the absolute necessities. So maybe it's 20 hours of care a week that are being provided to the beneficiary, and maybe they need more care than what is traditionally paid for, and you've tried to ask for more services through all-text and you haven't gotten them. So maybe we need to use the trust for the extra money, or for the extra services, because there's extra money in that trust. And obviously what we want to do is help that person be as independent, as happy, as we can to make their life better. Now, I don't have a money tree, So we have to have money to put into a special needs trust, but there's no cap on how much can be in it. You could have a special needs trust with $5,000, or you could have a special needs trust with $10 million. The amount in a properly drafted trust does not impact the benefits in any way. Now, how the money comes out might have an impact on the benefits, or if the trust is not drafted appropriately, that might have an impact on benefits, but the amount won't have any impact. So we're going to talk about two different categories of special needs trusts. And I know this can be super confusing, and I wish that we had different words. Whoever started doing special needs planning, it would have been great if they had been slightly more creative, or if the statute had been slightly more creative, but it isn't. So we're going to categorize what I would call first-party special needs trusts from third-party special needs trusts. So in your head, think and remember that a first-party special needs trust means that it's the money of the beneficiary. So sometimes this is because a beneficiary who's on benefits, maybe somebody died and left money for that person. Grandma left $10,000 outright to your child who's receiving SSI or all-tax benefits, and now they're over the $2,000 limit. That's the kid's money. Even if the kid, if it never goes in the child's account for whatever reason, it's still the kid's money. And so in order to preserve the benefits, their money would potentially go into what we would call a first-party special needs trust. This also happens sometimes when we have a beneficiary who is injured. So maybe the beneficiary wasn't receiving benefits and then gets involved in an accident. Now they have a traumatic brain injury, something else happens, and they receive money as part of a jury award or a settlement. Again, if we want to put those funds into a special needs trust, it would be a first-party special needs trust. And then we have two categories to make things more confusing. We're going to talk about the estate planning or third-party special needs trust in a minute, but let's just stick with our first-party trust for now. So then we have two categories of these kinds of trusts. Both of them require that funds left in the trust would go back to the Medicaid programs that provided services for that beneficiary. The first kind of trust is sometimes referred to as a D4A trust. That's the kind of trust that an attorney drafts that may appoint you to be the trustee. And so that's an individual trust that sometimes would require court approval before the money can go into it. And there are restrictions on how the funds can be used when they come out. And then we have what I would call pooled special needs trusts. And so those are trusts where they're run by nonprofits. And so we have a professional trustee to manage those funds. And instead of having to draft a trust document, you as the parent or the guardian or the conservator would have the right to sign what's called a joinder agreement. And that says, I want to put this person's money into the trust that you already manage as a sub-account. So I put my money in, nobody else gets to use that beneficiary's money, but it's all managed from an investment standpoint by the pooled special needs trust. But again, with a sub-trust for the share that's for that beneficiary. And again, the trustee has total control over the use of the funds. At the death of the beneficiary, the charity would be able to retain some of those funds, and some of those funds would go to the state Medicaid agency. Now, the agency, the state Medicaid agency or all-tax, only gets the money that's left in the trust after the beneficiary's death up to the amount that it paid for the care, either from the time that the trust was created, typically. So you can then say who gets the money afterwards if there's going to be money left over. Maybe, there was $10,000 and they used $1 million worth of services. The state is only going to get what's left in that trust. And we do these when we don't really have a choice. So if you're doing your estate planning, which we're going to talk about in a little bit, you want to set up a trust that's not one of these because you have the freedom to do that. This is when money has come in, as I said, traditionally a personal injury settlement, or funds from a probate where there was no planning done to set up a special needs trust. And so the funds are going to go into this account. Now, there might be other things that you could do to avoid a special needs trust in those instances. You know, maybe the amounts are not large and there are things that the person needs. And so as long as it's spent in the same month that the funds come in, the person should retain their benefits. Maybe some of the money is going to be spent and some of it's going to go into a special needs trust. Maybe the funds, there's up to 15,000 can go into an ABLE account. So maybe some funds are going into the ABLE account, or again, the amount is less than that $2,000 or the less than 15,000, it can go to the ABLE account. And now it's protected and the person still only has less than $2,000 outside of the trust. But sometimes people call and say, well, I don't want to do that with that payback provision. We don't have a lot of great other options. You know, if there's going to be $100,000, probably there aren't $100,000 worth of stuff that that beneficiary needs. So just something to think about. So when a special needs trust is in the works, we want to kind of think about what the issues are. So these can only be created for folks who are under the age of 65. So again, this is not, which we're going to talk about next, or estate planning trusts, and those don't have any age limit on it. This is when the beneficiary is receiving the money directly. If it's over the age of, person is over the age of 65 and money is added to that trust, that's considered a transfer, and it will delay the all-tax eligibility or lead to somebody being no longer eligible for SSI and some kind of a delay on that. It's only the assets of the disabled individual. So I wouldn't put my money into a first-party special needs trust for the benefit of somebody else, because I can do other stuff with the money that's mine. It's only the money from that disabled individual. And that individual has to be the sole beneficiary of the trust. So if you have 3 kids with disabilities, and heaven forbid they were all injured in an accident, or they all got money from a probate, which wouldn't be the end of the world, of course, more money is always good, you would have to set up a separate first-party special needs trust for each of those beneficiaries. Again, we're not talking about the kind of trust that you do as part of your estate plan. This is when the money has come directly to the beneficiary. And then we have a limit on who can actually create the trust. So a competent disabled beneficiary can sign the joinder agreement for a pooled special needs trust, or can sign their own special needs trust, but they cannot be the trustee. Otherwise, it has to be a parent, a grandparent, the guardian, or the court, and not a conservator. The statute is very clear. So if we have to go to court, then we want to make sure we have the right parties who can actually establish the trust, or even if we don't have to go to court, we want to make sure we have the right person in place who can establish that trust. Traditionally, we're going to end up in a court situation unless the beneficiary is competent, because, for example, if they do not have the capacity to sign their own trust and they were in a personal injury action, they're also not going to have the capacity to determine the settlement, sign the release documents, authorize the funds to go to the trust, authorize who the trustee is, all of those things. So oftentimes we end up in court, even though the court isn't the one establishing the trust, because we have a parent or a grandparent or a guardian. And then, as I said, the trust has to have that specific language about reimbursing the state up to the amount of Medicaid services. One of the questions that I commonly get is, well, what if we've moved around a little? And so the beneficiary has been in different places. So the trust would say that the states would figure out how much each of them are going to get if, in fact, there are funds left when the beneficiary passes away. So then we have third-party special needs trusts. So these are the kind of trusts that your estate planning attorney can do, that we do in our office. So I have a niece who has Down syndrome, as many of you know. And so I drafted a third-party special needs trust, and my mom, as her grandmother, says the share for her would go into that special needs trust. My husband and I have no children, so the share that goes to my nieces and nephews goes to them except for the share for this niece, and that share goes to that third-party special needs trust. You can have a third-party special needs trust for a whole variety of disabled beneficiaries. So if you have more than one child or more than one beneficiary, you can have it so it's what I would call a pot trust, which means the trustee, all the money's in one lump, and it doesn't matter who's using the funds or who the trustee's using the funds to benefit. Or you could say it's for, two people and they each get 50%. So we're going to create two separate kind of sub trusts when the money comes in. And so that if one person has higher expenses, their trust is going to get depleted faster and not negatively impact the other beneficiary. You do not have to report these kind of trusts to the agencies that provide benefits until there's money in the trust. So if you open an account in the name of that third-party special needs trust and you put $5,000 in it, you must then report it to the agencies so that they can review the trust. Lots of people think, well, my lawyer did it. It's perfectly fine. I don't have to tell anybody about it because its whole purpose was to make sure that my kid would keep benefits or my teenager or whatever. But the fact of the matter is the agencies that provide services, they have to approve that trust because they're the ones that are providing the services or the funds. And so they have to make sure that it meets their requirements. Now, most of the time for Altex, if they have an issue either with the first party special needs trust or the third party special needs trust, they would provide notification to say, article whatever, section whatever, doesn't meet our requirements. We need you to rewrite it and have this sentence in there. So most of the time, both of these trusts will have a provision that says it's irrevocable, except that the trustee would have the authority to amend the trust to comply with current rules, laws, and regulations. And so that gives us the flexibility to get it updated so that it could meet the requirements. And same with Social Security. Their rules actually say they're supposed to tell us what's wrong with the trust, exactly what section and what needs to be corrected, and provide the regulation or what's called the POMs that tell us why that section or that sentence, whatever it might be, doesn't work. And then we can get it amended and so that benefits can be retained for that individual. If you ever, when you report, if you ever get a letter back from the agency saying that we are counting your trust as a countable resource and you are now no longer going to be eligible for benefits, please make sure you get that to your attorney as quickly as you can. If they're already receiving Social Security benefits, we only have 10 days to ask for the reconsideration or get the amendment done, or the benefits will be stopped, and then we're going to have to submit everything, and there may not be any back pay to go back and get the services they were getting before. And unfortunately, often what happens is that when somebody loses their SSI benefits, notice also goes to access. And then you get the, we're concerned about whether you meet the access requirements, and now their health insurance might be at risk. So we want to avoid those issues. So just make sure you get counsel as soon as you can, because if you wait too long, you're going to have to then go through the reconsideration or appeal process, which can take a very long time, and you'll be without benefits while all that is happening. So we want to get those things straightened out as quickly as we possibly can. So anybody can create a third-party special needs trust. Anybody can contribute money other than the beneficiary to a third-party special needs trust. It can own a house, it can own a car, it can buy whatever is going to benefit that beneficiary. So if you have special needs beneficiaries in your life that you would like to leave funds to in your estate plan, I strongly encourage that you get this set up. Now, it can be done as its own trust. It can be done as a subtrust in your trust. It can be done as a subtrust in your will that springs to life when you pass away and the probate happens. So lots of different options and ways to control the cost. So depending on how much you have that you can spend on the project and how much is going to go into it, that might direct which of those options you choose. My preference is to be able to do a standalone document, not because it's, costs you more money and therefore I make more, but because we do have to report it to the agencies, and it's much easier to send, this is the trust, than to direct the agencies to, you know, Article 8 that starts on page 40 and goes to page 45. And because you have to provide the whole document. So if it's a subtrust of your trust, you're actually sending them the whole agreement. If it's in your will, it again isn't going to happen until you pass away. And so both with a subtrust in your trust or your will, sometimes it's more difficult to name that IRA or that life insurance as a beneficiary. So to have the trust as the beneficiary. So if you have your own document, you can say, you know, life insurance to the Joe Smith third party special needs trust, and it's already a thing. So it's just easier, but it's not the end of the world. That's why we have different options. So there's chocolate, vanilla, and strawberry in the world. And again, you don't have to report it to the agencies unless it has money, but once there's 1 penny of assets, has to be reported. So as I said, we have some greater restrictions on first party special needs trust as to how they can be used. We have to do an annual budget with All-Tex. If it changes, you have to get it updated. You have to wait 45 days before you can start making distributions from that first party special needs trust. The person's on All-Tex benefits. Provide accountings to All-Tex on an annual basis, versus our third party trust, which, you know, as long as it benefits the beneficiary, that's terrific. You can set it up for lots of different beneficiaries. You have to report it to the agencies, but they shouldn't be entitled to accountings because they're not a beneficiary, right? In the first party setting, they get the money that's left over when your beneficiary passes away if there are funds left. So they want to make sure you're not overspending. But in the third party special needs trust, it's not their money. It's never going to be their money. And they understand that you could just say that that beneficiary is disinherited and doesn't receive any assets. So that is why I think there's a lot more flexibility on those third-party special needs trusts. So the trustee is obviously a really important either person or entity. It's a really important role, and you want to make sure that you've chosen somebody who will actually be there during the life of your beneficiary. You know, if you name your sister and she's the same age as you over a special needs trust for your young child, the question is that trustee still going to be around when we actually need them, when you pass away? So it's really nice to have a list and not just one person, and to say, well, what happens if the trustees I've listed are unable or unwilling to serve as trustee? And maybe you want to have a corporate entity or a licensed fiduciary as the kind of final trustee in case there isn't anybody else around to serve in that role. And of course, you want somebody who can manage money well, because they're going to be in charge of your vulnerable beneficiaries' funds. And we want to make sure that they're using those funds correctly. So as I said, just so you remember, first party special needs trusts are the beneficiary's money. Third party special needs trusts are the money of you or grandma or grandpa or aunt or uncle or brother or sister. There's no payback requirement to the states in the event that you did a third party special needs trust. So for my niece Marissa, it says, you know, it gets used for her during her life, and when she passes away, it goes to her siblings. So the state doesn't have any right to the funds that are going to be in that trust. Talked about, you know, the choices, the ways you can have that trust be created. And again, it's easier if you want to name the trust as a beneficiary of whatever when it's its own trust, but whatever works for you. But naming your child as the beneficiary and they're on benefits doesn't get it to the special needs trust. So if you're going to have that as pay on death or the beneficiary, you would want to name the special needs trust or name your trust, which then has whatever percentage is going to go into the special needs trust for that beneficiary. And then you have reporting requirements, you know, whether you have a trust or not, but if you have the trust has to be reported. But if you don't have a trust, you still have to, you know, if there's a change in marital status of the beneficiary, they get a job or they lose a job or their rate of pay changes, all of that stuff needs to be reported to the agencies because it may impact benefits. And for Social Security or SSI benefits, it might decrease how much that beneficiary receives. So you just need to make sure they know about it. Obviously, if your loved one passes away, you would want to tell the agencies that the person has passed away. So I do not see any questions in the Q&A, and I actually don't even see that I have a chat box. Oh, there we go. Sorry. And I don't see any questions in the chat box. So I've either totally overwhelmed you, or I was just so brilliant that you didn't have any questions. So Talia, it looks like you have a question. Is it possible for you to type it in either the Q&A or the chat? And I'll do my best to answer it before we move on to the guardianships. So anybody else, if you have any questions in either the Q&A or the chat, is totally fine. So the question is, how long does it typically take to arrange for a third-party special needs trust? So it would be done, again, typically by your estate planning attorney. I'm sure there are some on the internet. And so it just depends on what the backlog is for that attorney who's going to draft it. Our usual turnaround time is 2 weeks from the time we meet with the client and get all the information and know what we're doing to get a draft out to the client for review, and then however long they want to take to review it or have a conversation with us, and then to get it signed. The trustee, if the successor trustees don't have to be present and they don't have to sign, only the person who's creating it and the current trustee to sign the document. And then another question about our family trust can handle this also, right? And the answer is, so the answer is shortly yes. So if somebody is going to leave money to your child who has special needs and is receiving benefits or would be eligible, you would want them to have the gift go to the special needs trust. So if it's a sub-trust of your trust, then it would go to the Marissa Special Needs Trust, a sub-trust of the Emily Kile Trust. And you would want to open an account, get a tax identification number, and then the funds would go into that trust. If they leave a gift outright to the child, it's not in the Special Needs Trust. And so if now they're over the $2,000 limit, they might no longer be eligible for their benefits. So again, if they want to leave a gift to all of the kids, and so they say that it's going to go equally to all of the beneficiaries of the family trust, they can do that. They could say that money goes to, my daughter, and if my daughter's deceased, then the portion for this special needs beneficiary will go into the special needs trust. But just an outright gift to a beneficiary doesn't get it to the special needs trust. It has to be directed in that direction. So somebody said it's confusing to me about reporting the third-party special needs trust. So it only has to be reported when it owns something, when you've opened an account and it has some money in it, or it owns, property or whatnot. And then a copy of the trust with an explanation that this trust is a third-party special needs trust. The money came from whoever, from me. I put it in the trust for the benefit of my kid, or came from grandma. And it was directly deposited into the account, some kind of a reporting. If you used an attorney to draft the trust, oftentimes for not very much money, once the trust is funded, the attorney would be willing to send the letter in and do the explanation, because you want to make sure that they are looking at their right regulations when they get your trust document. And then we have two, so I'm going to answer one question, then we're going to go back to Abel for a moment. So the question is whether a third-party trust can just remain empty for a while. Absolutely, absolutely. And 9 times out of 10, the special needs trusts that we draft as part of an estate plan, there's not going to be any money in there until mom and dad are both deceased. So it's just going to sit empty, for however long they're living. And when they die, then their assets are going to go to the kids. And one of the and the portion that goes to the special needs trust will go to the special needs trust at that time. And at that point, whoever the successor trustee is going to report it to Altex. They don't have to do a budget or any of that stuff for these estate planning trusts, and there's no impact on Alltech's eligibility for that properly drafted trust. It can have $10 million in it, and it's totally fine. So 2 questions came in with regard to ABLE accounts. What's the difference between a trust and an ABLE account? And the other question was, does it make any sense basically to take money out of the third-party special needs trust and put it in the ABLE account? So ABLE accounts, you can only put in up to $15,000 per calendar year per beneficiary. The funds in an ABLE account will grow on a tax-free basis, and distributions for the benefit of the beneficiary come out on a tax-free basis, income tax-free basis. For most people, there's not very much money in the trust, so the tax ramifications are pretty small. If it's cash, there would be none. If it's invested, again, you're only talking about the growth in the investment account, not the principal that went in. So again, the amount of money that's going to be, the amount of tax is probably going to be fairly small. So I don't see that as a huge issue. A third-party special needs trust, as part of your state plan, has no payback to state Medicaid agencies. Money in an ABLE account at the death of the beneficiary has the same payback requirement essentially as the first-party special needs trust that I talked about at the beginning, that are the beneficiary's money. So if you take money out of a third-party special needs trust and you put it in an ABLE account, you've made a gift of your money to the beneficiary, and it will now be subject to the payback requirement, but it would not have been subject to the payback requirement in your estate planning, in your trust, or in that third-party special needs trust that you set up. The money in an ABLE account does not count against the beneficiary for SSI or Alltech's benefits, as long as the amount total in the account is not more than $100,000 for SSI, and it's like $600,000 for Alltech's benefits, something like that, if they don't have SSI benefits. So I would not find it, except to pay for potentially food and shelter expenses out of an ABLE account, I don't know that there would be a lot of sense in moving money from a third-party special needs trust to an ABLE account. And under our statutes, you cannot move money from a first-party trust to an ABLE account. So you just have to figure out, does it make any sense to do it, to put the money in the ABLE account? So another question is, if the third-party trust remains empty and then grandma leaves money to the parents, can the parents put it into the third-party special needs trust? And the answer is yes. Unless grandma said this money goes to little Joey and the check is made out to Joey, now it's first-party money or goes into the ABLE account, not into the third-party special needs trust. Assume I die and a third-party special needs trust for my adult child becomes funded. The funded trust is now reported to Alltech's. But what about the trustee dispensing funds from the trust? Does that impact the $2,000 limit for Alltech's? And the answer is, as long as the money doesn't go directly to the beneficiary, they're not going to be over the $2,000 limit. And you don't give cash to a person on Alltech's because that's income to the beneficiary, which might impact benefits. Along with SSI, that's income to the beneficiary. But the trustee can, as I said, buy a phone, pay the cell phone bill, buy clothing, buy games, put apps on the phone, whatever. Pretty much anything for the beneficiary, and that shouldn't impact eligibility. Person says they have a son with Down syndrome who should receive SSI when he turns 18. If he doesn't spend all of the SSI every month, are they going to be over the limit? And the answer is yes. So you want to use SSI money first for expenses, or after it comes in, move it over to the ABLE account. You can contribute that, anybody, a total contribution of $15,000 a year into the ABLE account. So sometimes people use it for that, or you use the child's money to pay for their share of haircuts, and you use it to buy them a new phone. So there are other things you can spend it on. You also could do a rental agreement, so you're paid for food and shelter expenses from the SSI, and then the funds come into your account, which is outside the scope of today's discussion, but is also a possibility. Question about whether the rules have changed. The family trust was set up by an attorney and there's special wording in there to receive gifts. So I have no idea when your special needs trust was set up to know if the rules have changed. Generally, the third party special needs trust rules have not changed very much, or that would impact the eligibility question. But again, if somebody leaves a gift outright to a special needs beneficiary, those funds are counted for that beneficiary and you cannot put them in the special needs trust. If the gift is given to the trustee of the trust, then it's not a gift to the child, and then it's perfectly fine and won't put them over the limit. So I know it's super confusing and it's really hard for me because I can't see your facial expressions to know if what I'm telling you is helpful or whether you're still quite quizzical. Special needs trusts are super confusing. That's why people focus practices on that when they're doing estate planning rather than on other issues. So maybe you have an estate planning attorney that you've used who's great with tax stuff, which is not me. But maybe they're not as great with special needs planning. And we often work side by side with attorneys who don't do special needs planning so we can protect people and make sure you're getting the best advice that you need. So I hope those answers were helpful. It looks like they've slowed down in terms of questions. So I am going to move on to guardianships. And if you have other special needs questions, if we have time at the end, by all means, you won't get, I'll answer the question still. So guardianship's a court action, and its goal is basically to keep you as the parent as if the person was a minor child, even though they are 18 years old. So if you are filing for guardianship for a minor, 17 and a half years or younger, you're in the juvenile court, and you would only have to do that if you don't have some kind of parental rights. So if you're the biological or adoptive parent, you don't have to file for guardianship until the kid is 17 and a half or 18 or more than 17 and a half years old. Until that time, you do not have to file for guardianship because you're already the parent. You already have all the rights to make all the decisions for your child. Sometimes we have grandparents who have taken over because the child is deceased or in prison or otherwise cannot care for the child. And so they may have to go do the guardianship route if the child's not going to be adopted by that person. Remember that we're taking away somebody's rights, so we want to make sure that we're doing guardianship where it's needed and not where it's not needed. And lots of people always ask me, should I do the guardianship for my kid? And I don't know your child or this person that might need guardianship. So conversations with the school, conversations with the child's or the individual's physicians, and think about, if I wasn't here, can they make these health decisions for themselves? Could they figure out where they're going to live on their own? So they're hard decisions to make, but if your kiddo is somebody who really still needs some help, then, guardianship is possibly the way to go. We need a physician or a health professional's report to support the guardianship, and we're going to talk about some other people who are also looking out for your beneficiary. But oftentimes it's because of, Down syndrome or autism or some other developmental disability that the child has that they're going to need help for a while, or some kind of mental illness or drug addiction or something else that's going on for that beneficiary. Something that's important for you to understand is that the rules for guardianship in the probate division are the same, whether your kid is 17 and a half or it's your 100-year-old dad who has Alzheimer's. So everybody gets treated the same. And I know that's really hard sometimes for parents. You've been raising your kid the whole time and you know them inside and out, and you feel like I should just be the guardian and I shouldn't have to have a hearing and we shouldn't have a court investigator. It feels very intrusive, and I feel terrible about that for you. But the rules are the same. So once somebody turns 18, they're considered to be an adult. And until a court says they are incapacitated, they are deemed to have capacity to make all of their own decisions. What the rules do allow us to do, which I think is super fortunate, is file for guardianship up to 6 months before their 18th birthday, because then we don't have a gap in time. The orders would go into effect on their birthday, even if you were in court 3 months prior or 6 months prior. They go into effect on the birthday because, as I said, until then, you have all the rights to make all of the decisions for that individual. Sometimes people ask me, so if I didn't file, I can't file at all now because I didn't file by 17 and a half? No, you can file anytime you want. You just can't file before 17 years and 6 months. So you can file at 18, you can file at 21, you could file at 37 and a half, you can file when the person's 100 years old, whenever it is you feel that you would want to do the guardianship. Remember that it takes the court, so let's just assume all the paperwork's done. You probably won't have a hearing for about 6 weeks from the time you file. And if you're close to holidays, you might have a longer wait because the courts are, the judges and judicial assistants and commissioners take vacations also. So around Thanksgiving, around Christmas, around the holidays, it might be longer because we don't have all of the commissioners going at full steam ahead on their calendars. So just plan accordingly. So guardianship's a big deal, and there's a lot of paperwork that needs to be done. When I say you have to present evidence, if there's no objection to the guardianship, it's a 5-minute hearing. It's really not a huge deal in terms of a time commitment for the hearing part. Obviously, you still have to take care of your person, which probably is a big time commitment, but it's not like a trial where you have to go sit in the witness box and all of that. What I tell people is the only part that's kind of like television is you have to raise your right hand and swear to tell the truth, the whole truth, and nothing but the truth. And the person over whom you want to be the guardian has the absolute right to object. So they could say, I don't need a guardian, I don't want a guardian, and if I have a guardian, I don't want it to be that person. So they have a right to do that. They're going to be appointed an attorney, and every single guardianship in Arizona, we have to have a hearing. We don't just do it on paper. We can do limited guardianship, so we can retain driving privileges. They can retain the right to vote. They can retain both. They can retain one or the other, or they cannot retain those. For driving, even if the doctor has to say that they're safe to drive now, even though they don't have a license, just that they would be if they were able to pass the exam and whatnot. And the court is going to rely on the information provided by the doctor. So if the doctor doesn't say they can drive or doesn't say anything about it, the court will assume the answer is no. So if you want your person to be able to retain the right to get a driver's license or keep the license they have, you want to make sure that the health professional completes the report to be clear that they have the capacity to operate a motor vehicle. We don't want anybody hurting somebody. So the court's very concerned about handing out driver's licenses or allowing them to take the exams for the license. The other part is that even if the license is suspended as part of the guardianship, it doesn't have to be that way forever. So if your person isn't ready yet, but next year, the year after, or in 10 years, you take them to a driving school on a simulator or otherwise, and they're doing well, and the report is that they have the ability to, to take the test and operate a motor vehicle, and then you get your physician report to say the same, we can go back and amend the orders and the letters and get those rights back. So they don't just get handed out. We have to have evidence for somebody to keep their driving privileges and their right to vote. But just because they're suspended at one point doesn't mean they're suspended forever. And even though we call these permanent guardianships, nothing has to be permanent. So if they get better, they mature, whatever it is that's going on, we can go back again and petition the court for the termination as long as we have a health professionals report to support that. As I said, there's a whole lot of paperwork. If you're doing it on your own, you can go to the court self-service website. Make sure you follow the instructions exactly the way that they're written. If it says that you need to do one thing first, if it says you need to provide so many copies, make sure you follow exactly the rules and instructions that are being provided. Otherwise, when you get to your hearing, it may or may not go forward. So the court has a list of priorities for who can be the guardian, but it doesn't mean they have to follow that order. So if both of your parents have Alzheimer's, maybe the spouse is really not the right person to be the guardian. So, or maybe a parent isn't appropriate and a sibling is a better choice. So the court's going to take the evidence to figure that out, but the folks who have higher priority need to get notice. So if they wanted to object, they could do that. And you have to complete an affidavit. And if you have a criminal history, a felony within the last 10 years, that may impact your ability to become the guardian, or a history with the Department of Child Safety or Adult Protective Services, that may be a problem. We can have co-guardians as parents. We can have co-guardians with you and your other typical kid who's over the age of 18 to be co-guardian with you. Co-guardians have all the same rights and responsibilities. If you want a backup guardian, if something happened to you, you do that in your estate planning documents. So in your will or in a separate nomination of guardian, you can say, hey, if something happens to me, this is who I think should become the guardian. And then that person, if the bad thing does happen to you, would submit that to the court so that they can become the guardian right away, and then go back and have the hearing and do all the things they need to do. I talked about the fact that everybody who is potentially going to be under guardianship will get an attorney appointed by the court. Those are private attorneys and will expect to be paid unless your beneficiary is indigent. If they're on SSI or Altex, they don't have to pay any of the fees. We need a health professional, usually a physician, but sometimes a nurse practitioner or physician assistant to complete a report. And there'll be a court investigator who's court staff who are typically doing the meetings virtually, but that at some point I assume they'll come in, and they're the eyes and the ears of the court to make sure your person seems safe and explain how guardianships work. We always have to have hearings. They're done virtually now, and I think for the foreseeable future, for these initial appearance hearings or where there's no objection by anybody. So they're done on a Teams-based product called Court Connect, and you can show your video or just do it telephonically by voice. It's nice to be able to see you on those. Courts like to see the people like they did in the courthouse. And it's great if the person who's going to get a guardian is able to pop their face into the video as well so the court can see them. There is a mandatory training. And so there's one on non-licensed fiduciary training and welcome to guardianship. It's free. I've given you the website. If you're thinking of doing guardianship, I would recommend that you watch the videos. They're little slideshows, about 20 minutes each, and they really do go through your responsibilities and what to expect. And if you are going to be the guardian, there's a certificate at the end that needs to be dated and signed and filed with the court so they know that you know what your responsibilities are, particularly if you're doing it on your own without an attorney. But even if with an attorney, you must complete the mandatory training before what are called the letters of appointment would be issued. If your person is on SSI or Altex and they don't have any assets, including no funded first-party special needs trust, no funded third-party special needs trust, and no ABLE account, then you would want to make sure you're going to ask to have all the fees and costs waived or deferred at the time that you file, and then ask for the court to waive those fees at the hearing. It's really hard to get your money back, so it's much better to just do it at the time of filing. Guardianship, the guardian decides where somebody lives, what their health care is, to consent or not consent to medical treatment. Typically, they must consent to marriage or adoption, and they can handle up to $10,000 of funds. If you are the representative payee and the person gets Social Security, and they only have Social Security, then you don't have to apply to be the conservator, and I wouldn't. And a guardian can handle up to $10,000, which typically is outside of your rep payee responsibilities. You might also be the trustee of a special needs trust. You don't need court approval typically to do that. It would be part of the trust document as to whether that required court approval. If the incapacitated person moves out of the state of Arizona, it's good to tell the court before it happens. and you would get an order saying, yes, it's fine. That goes to your new state. Your new state would say, yes, we're happy to accept. And that order comes back to the state of Arizona, which terminates your guardianship here. You don't really have guardianships in more than one state at the same time. Almost all the states are part of our Uniform Act, so you wouldn't have to have another hearing. That is just done on paper, even if it's going to be a different guardian. So maybe you're the guardian in Arizona and the person's moving to Illinois. There's a different person in Illinois who's going to be close by and should be the guardian. Even for those, we typically don't need to have a hearing. And as I said, you can terminate the guardianship when it's not needed, but it requires a court order. So you have to submit something to the court in order to be able to terminate the guardianship. If your loved one is competent, then they can do powers of attorney over here. Where there's no court action, they can revoke it anytime they want to. If it's a guardianship, they can get as mad as they want at you, but they don't have the right to terminate the guardianship. Only the court can do that. Talked about asking for your deferral of fees. If they have an ABLE account or other money that's theirs, that has to be reported as their funds so that the taxpayers aren't paying expenses that the person has their own money to pay for. So if they don't have any of their own money, then we would ask for the deferral at the time of filing, and we would ask for the waiver at the time of the hearing. So I know I went through that really quickly. I want to be cognizant of your time, and it's about 5 minutes to 1 according to my clock. So these are some resources that I think are really helpful for people. You can investigate the guardianship anytime you want, but remember, you don't file until the kid is at least 17 years and 6 months old. Or they have Alzheimer's and they're 90 or 85 or 60. On those, you can file anytime. You just can't file before 17 and a half. So I want to see what questions we might have here. What kind of conflicts of interest arise in a guardianship? Well, sometimes we have divorced parents who don't like each other. And so it's hard to be co-guardians with a person that you don't like and don't want to have to communicate with. And in those instances, you know, sometimes you just have to do battle in the probate division to figure out who's going to be the guardian if you can't work together. Sometimes we can craft an order that says one of you is the guardian, but the other parent, you know, has rights to information. They just can't be decision makers, and that you as the guardian will let them know if there's been a change in where they go to school or who their providers are to try and smooth that out. If we have co-guardians and they don't agree, you are going to end up probably back at court so that the court can help figure out what the court thinks, and we'll hear from court-appointed counsel as to what they think are the best for that person. Somebody's asked about what the costs are for our firm to do guardianship or estate planning or trust work. And you can absolutely contact my office, and all the work is done on a flat fee basis. And my staff would be more than happy to provide information to you about what those costs would look like and provide you with sample fee agreements. So happy to do that for anybody who would like that information. Let's see. Somebody who has minor children, and it looks like maybe they have some kind of a terminal illness, and there are different fathers to the kids. The mom wants to leave the kids to her mother, so to the child's grandmother. And can she just leave them there? And is that okay? Or is something else going to happen? So the grandma really needs to apply to become a guardian over the children. And I don't know whether the dad's parental rights have been terminated, whether the dads have outstanding child support requirements, whether they're on the birth certificates or they're not on the birth certificate. So lots of issues going on there. But typically you have to have some legal authority to have those children with you on a full-time basis when there's not a parent, and to enroll them in school, and to become the person who is the authorized representative for various government benefits. Those programs are going to want to know, why can I as the government benefit program communicate with you. So it would be important to figure out how to make that happen. The court costs for filing a guardianship are about $800, I think. So there's the court investigator fee and the filing fee. And I think those two together are about $800. But our legal fees, again, just contact the office 480-348-1590 or info@kilelawfirm.com, KILEFIRM.com, and we would be more than happy to give you any information about fees and costs. We will have a recording and it will go up on our YouTube page as well as on our website. So feel free to look at it again or tell your friends about it so they can see what's going on. And let's see. Became guardian and conservator when an adult child was in a coma post an injury, and she's now able to make decisions on her own, but I haven't terminated those roles, the guardianship and conservatorship. Am I correct that I need to relinquish those through the court? Could my daughter still grant POA for reasons? And would resigning change your role as trustee? Lots of great questions. So yes, you have to petition the court to terminate a guardianship or a conservatorship and provide the physician information that about the person is now able to make their own decisions. Sometimes the court, well, if you have a conservatorship, probably there's still court-appointed counsel, but sometimes the court would reappoint court-appointed counsel to review and make sure everything's okay. If you're the conservator and you are managing money, the court will require a final accounting typically so that they know that the money was handled correctly. Terminating the guardianship or conservatorship doesn't have anything to do with your trustee responsibilities. If you have to report to the court as trustee, that would probably continue just the way it was before. And absolutely, if your kid got better, which is fantastic, they can definitely do a power of attorney instead of you sticking with the court route of the guardianship and conservatorship. So another question that came in is the person is mentally ill and has run away from home and gone out of the state. So you would petition for the guardianship in the state in which the person is residing, even if you do that for a temporary guardianship only to explain that, you know, Arizona is their home and you need authority to bring the person back. If you were appointed as guardian in Arizona already, you can probably file with the court there to get the letters or orders recognized in the state in which the person has gone to. You might even be able to ask for law enforcement help. But if you've never been the guardian, you would petition in the state in which the person is residing. Where you, as the guardian, can live anywhere, the court has jurisdiction and needs the guardianship in the state in which the incapacitated person is residing. You've agreed to have court jurisdiction over you as the guardian, but the action is the state in which the person is residing. So if you're granted guardianship, can you enforce it? That is, can you compel the incapacitated person to live at home, take their medicine, pursue what you think are appropriate medical care? You know what? That's what you're supposed to be able to do, but it's a piece of paper. And much like an order of protection will not stop the bullet from the abuser, it's just a piece of paper. So if they're mentally ill and you have mental health authority, you can involuntarily admit that person to a locked behavioral health care center, whether they want to go or not. They would have court-appointed counsel and you would have to provide notice to court-appointed counsel. If they're you can set up any kind of medical treatment that you think is appropriate for that person and in their best interest. But you know, you can't send somebody to therapy and make them talk. You can't make them do physical therapy because if they're not going to move their arm the right way, you can't do that. It's the same role as you have as a parent to a minor child. You can only do what you can do. You can review medical records, you can be with them at the medical appointments, you can set up medical appointments, you can do what you need to that you think is in their best interest. You can compel where they live. So if they're going to go to a group home, you can admit them to that group home. You can sign the paperwork to admit them into that group home. But if you make them stay home and they don't want to stay there and they run away, it's not like you can put bars and lock the house and make it so that, well, typically that they can't leave, although I suppose maybe you could do that as well. It's not kidnapping to keep your person that you're the guardian over where they are. If they have court-appointed counsel, though, they're entitled to talk to their attorney and they're entitled to file with the court and object to what you're doing, and you cannot stop them, nor should you. Those are their rights to pursue, to let somebody else know if they think that the situation is not appropriate for what their needs might be. So guardianship, as I said at the beginning, it's a big deal. It's a lot. It's a process. It's a journey. I thank you all so much for joining me today on our presentation on special needs trust with a little bit of ABLE accounts thrown in and guardianship. I hope you learned something that you maybe didn't know before. And if we can help you in any way in the future, we're certainly here to do so. I wish everybody the very best. I hope you're all staying healthy and well. And we try to do these every month. So we hope to see you on our list of participants at our next presentation. Everybody stay well, be well, and I'll talk to you soon. Thank you.